Assalamualaikum everyone. My name is Ahmad Muhaimin bin Abdul Halim, and our group today will review the case of the Volga case, which is the Russian Federation versus Australia, for the subject of the law of the sea. This presentation and slide was prepared by Ahmad Muhammad bin Abdul Halim and my fellow friend Mr. Kamaruzaman bin Cik Ali. Okay, the background of the case. This is the presentation. This is ICLOS case number 11, which is official case number. And the appellant for this case is the Federation of the Russia. The respondent, which is Australia. The court for this case is International Tribunal for the Law of the Sea, ICLOS, and the date for this case is 23 December 2002. Okay, for the fact of the case, on February 7, 2002, Australian naval official boarded the Volga, a Russian fishing vessel, while conducting a naval patrol against IUU Patagonian toothfish fishing in the EEZ of Australia's Perth and McDonald Island in the Southern Ocean. A few meters beyond the EEZ, the Australian Navy boarded the Volga. After being captured, the Russian vessel was brought to Fremantle, Western Australia. The master of the ship and 3 of the crew members were arrested. The master was then served with a seizure notice, stating that the Volga, as well as all of its net trap equipment and fish, could be seized until the owner or possessor made a claim with the Australian Fisheries Management Authorities. Following that, 3 members of the ship crew were charged with illegal fishing in the Australian Fisheries Zone with a foreign boat. The owner of the Volga then filed a lawsuit in Australian Federal Court to prevent the vessel's seizure. In response to the owner's request for the vessel release awaiting legal action, the Australian authority established a bond of around Australian dollars 3.33 million, potential fine of Australian dollars 412,500 for the 3 crew members and a good behavior bond for carrying a fully operational vessel monitoring system as a guarantee of non-repetition of IUU fishing in the Australian EEZ and compliance with the CCAMLR conservation measure until the end of the judicial procedure in the Australia. In light of this, the Russian Federation filed an ICLOS claim against Australia, requesting the immediate release of the Volga and its crew under UNCLOS Article 292 Clause 1. The tribunal decided whether the Australian bond was unreasonable and hence in violation of the UNCLOS Article 73 Clause 2 during the rapid release proceeding. These central questions found 2 more, which is whether non-financial requirement can be imposed as part of a bond and if a good behavior bond is justified. Okay, I pass to the next presenter, Mr. Kama.
The issue of this case that have been discussed have 5 issues. The first one is whether the tribunal has had adjudication and the claims were admissible. The second one is whether Australia had violated the United Nations Convention on the Law of the Sea. The third one is whether Australia should be ordered to release the Volga against a bond. The fourth one is what the form and guarantee should be. The final one is whether the hot pursuit by Australia is a violation of Article 111. Next slide. Okay, for the judgment, the tribunal judges the case based on the issue under Article 292 of the Convention to respond to the application that was represented by a Russia Federation representative. The tribunal decided that the application was admissible with respect to the claim of non-compliance with Article 73, paragraph 2 of the Convention. It must determine if the bond imposed by Australia and Russia Federation can be considered as reasonable under Article 292 of the Convention. For the first issue, tribunal judged the case by including the gravity of the alleged offences and the penalties imposed or impossible under the laws of the detaining state. The detaining vessel and the cargo seized, the amount of bond imposed by detaining states can be used to determine what the amount of bond can be considered as reasonable. Next slide. Okay, for the second issue, the tribunal rejected the respondent proposal for a good behavior to prevent future violation of the law of a coastal state and behavior and Australian behavior. And Australian behavior cannot be considered as a bond or security in international law of the sea. The tribunal determined that the extra non-financial requirement and good behavior would be in violation of UNCLOS Article 73, Paragraph 2. The tribunal argues that the action Australia did is unconcerned with assisting states in enforcing domestic rules and irrelevant. Next slide. In December 2002, the international law of the ITLO delivered its decision by 19 votes to 2 that the full court of the Supreme Court of Western Australia needed to uphold the appeal and order the 3 officers of the Volga that they can be permitted to leave Australia by what is considered as a reasonable bond. The Volga will be fined up to $1,100,000 Australian dollar, and the vessel its equipment and the cash were liable to forfeiture. The tribunal stated that both parties agreed that the fair value for the vessel were $1,800,000 and $147,000 and $460 for the vessel's gasoline, lubricant, and equipment. As negotiated, the vessel and its equipment had a total worth of $1,947,100. The tribunal determined that the sum requested by the respondent as $1,920,000 is reasonable under Article 292 of the Convention. As for the final issue, Russia decided to not have a proceeding and not sue Australia. Russia intended to have separate proceedings. However, Russia was reluctant to take recourse of the UNCLOS dispute settlement, and the motivation behind Russia was unclear. Okay, for the next presenter.
Okay, thank you, Mr. Kama. For the party arguments, the first argument is Russia claims Australia has violated Article 111 Clause 4 of the Convention that the subsequent hot pursuit was illegal, thus violated Russia's freedom of navigation on the high seas under Article 87 Clause 1 Clause A, because the first audible signal from the Australian Navy helicopter was transmitted while the vessel was on the high seas. Australia argued the legality of the hot pursuit should be evaluated in accordance with all the Article 111 and not only Paragraph 4. The reason for the hot pursuit is continuation of an act of jurisdiction which has been begun for the accident of immediate escape would have been begun within the territory. Australia's views on the legitimacy of seawater capture is not strong because signal can be issued using modern technology at best while the vessel is inside the coastal state authority. The second argument is legality concern Russia's status as a flag state. Professor James Crawford, representing Australia, pointed out that Russia had no real control over the Volga as required by Article 91 Clause 1 of the Conventions. The ship owner has freedom to choose any flag as long as he meets the flag state registration criteria. UNCLOS mandates a genuine relationship requirement between the ship and the flag state, but did not define the phrase. The majority of the researchers believe that a simple administrative step like registration is adequate to satisfy the genuine relationship criteria. The tribunal conclusion is necessity for a true connection exist between ship and flag and proper execution of the flag state responsibility. I pass to the Mr. Kama.
Okay, I will discuss about ratio descendancy. Just the tribunal some of the consideration to consider when determining a reasonable bond for vessels or cruise release under Article 292 of the Convention. The tribunal in the Comufco case lists the following consideration to consider when evaluating the reasonableness of bonds or other financial securities. A variety of variables according to the tribunals are relevant in determining the reasonableness of bonds or other financial securities. They include the seriousness of the claim offence, the penalties imposed or enforced by the returning state law, and the value of the detained vessel and the cargo seized. In the judgment 76 of December 2000, paragraph 66 said that the tribunal confirmed this statement in Monte Carlo case, but by added, this is by no means a full list of reasons. The tribunal also has no intention of establishing strict guidelines for the amounts of weight to be assigned to each of them. Next slide. The tribunal must consider whether the respondent's bail is reasonable under the convention. The purpose of Article 292 of the convention, as stated in the Monte Carlo case, is to harmonize the interest of the flag state in having its vessel and crew released quickly with the interest of the detaining state in having the master appears in its courts and pay penalties. The balance of interest established by Articles 73 and 292 of the Convention serve as the tribunal's guiding factor in determining the bond's reasonableness. Next slide. Okay, dicta. Judge Vice President Wukas. Vice President Wukas has voted for the Volga case, Russian Federation and Australia in favor of the tribunal's finding contained in paragraph 95 of the judgment. He also agrees with this finding with regard to their main objective, but at the same time, he distanced himself from all statements or conclusions in the judgment. The opinion of Vice President Wukas is the characteristic of her island and the McDonald Island. All these economic interests and concern do not exist in respect of uninhabited islands such as her island and the McDonald Island. There cannot be coastal fishing communities as there is no permanent habitation. Vice President Wukas give opinion about view of the above mentioned absence of permanent habitation and the geographical and climatic characteristic of her island and the McDonald Islands. It comes as no surprise that some interests and all concerns other than economic ones are appointed to as the reason for establishing the exclusive economic zones around this island. Next slide. Judge Masi has an opinion of the Volga case, Russian Federation and Australia. He voted in favor of the court decision in this case. The new sea regulation recognized coastal state exclusive sovereign rights to exploit ocean resources over which they have sovereignty or jurisdiction. It's worth noting that a lot of people have spoken out in favor of the coastal state's right to defend itself in order to protect its resources from illegal, uncontrolled, and unreported exploitation with disastrous results. I will pass to Ahmad Muhaimin.
Okay, for the dissent of the case, Judge Edward Shearer, Mr. Shearer said that he cannot accept the tribunal decision to reduce the amount of the bond established by the Australian authorities. Mr. Shearer preferred a decision similar with the respondent that the Russian Federation application be rejected. Thus, the amount and term of Australian bond should be upheld. The term bond and financial security should be given a liberal and purposely interpretation in order for the tribunal to fully account for the measure, including those made possible by modern technologies that found necessary by many coastal states and mandated by regional and sub-regional fisheries organizations to deter the plundering of the sea living resource through judicial and administrative order. Okay, for the comment of the case, this case illustrates the importance of the reputation in developing a dispute resolution plan, which is the dispute resolution plan should be made more comprehensive by the ITLOS. Second is this case is an excellent case for study for assessing the effectiveness of the international and national judicial institution, as well as their rules in guaranteeing international law compliance. The last one is the approach of ITLOS to establishing a reasonable bond. The approach of the ITLOS should be checked and make it more into the article and not by any mere principle, which is what I say is there must be a research about this issue, which is a reasonable bond to anything that happened in outside the EEZ or related to this issue. Okay, for the conclusion, this case exemplifies the international legal systems and internal morality and force. An important issue is that the effect of the countermeasure must be proportional with the injury experience, taking into account the right in question. According to the ICJ, when we consider the right in question, the coastal state right to conservation of a highly vulnerable species, the forfeiture of the vessel and the owner refusal to release the vessel owing to a greater bond amount is perhaps acceptable. But this not to mean Australian failure to fulfill its international obligations should be overlooked. Okay, that's all from our group. Thank you everyone.